advocating violence that would take place immediately, and they are advocating immediate violence under circumstances in which the immediate violence is likely. That is, standing in front of an angry mob and saying, do something right now. Every other country in the world, including but not limited to this one, thinks that that is too extreme. They believe that the problem of racism, the problem of racial violence, the problem of race discrimination is made worse by people who advocate race discrimination, who urge racial violence, and that ought to be prohibited. The counter argument, whether it be in the US or elsewhere, is of two varieties. One counter argument by free speech enthusiasts, of which I do not consider myself one. I consider myself more knowledgeable than enthusiastic. I will lead other people to be advocates. Free speech enthusiasts say two things. One, that under circumstances in which the discrimination and violence is not immediate, then people who hear the messages can think about the messages. People who disagree with the messages can argue against the messages, and that there can be debate about this as long as there is time for debate, as long as there is time for the other side to be heard. This other side, or this argument, rests on the belief that when there is debate between good views and bad views, over time the good views will prevail. Whether that's true or not is, again, an empirical question, and it's not self-evident. The other argument against this view, or the other argument against restriction, against prohibition, is that sometimes it is not clear what counts as race discrimination, what counts as racial hatred, and allowing some government agency or judge or jury or prosecutor to decide what counts as racial discrimination or what counts as racial violence or race hatred and so on is not so easy, and therefore it's dangerous to prohibit the incitement to racial hatred, so the free speech enthusiasts say, because ultimately people will use these laws to try to prohibit anything that they disagree with, even if it doesn't involve immediate advocacy of violence. The second form of hate speech is not speech that is addressed to sympathetic audiences, urging them to take actions against others, but rather a form of hate speech in which people are engaged in racial insult or racial vilification. That is, if people are insulted because of their race, if people are insulted by the use of racial epithets or racial labels, that is a form, so it is said, of direct harm. Not just the harm that may come when sympathetic listeners will do something to someone else, but a form of direct harm. That people are harmed as much when racial epithets and racial insults are aimed at them as they are harmed by certain forms of physical violence, especially the ones that may not be long-lasting. If people can be held liable when they punch others, should they be held liable as well when they use words to produce just as much short-term or immediate anguish or hurt or harm. And therefore, in many countries, racial vilification, racial insult, and so on also comes under the category of hate speech and is also prohibited. Third, and finally, in the category of hate speech, we have the propagation of factual falsehoods about matters racial or religious. Most commonly, we see laws prohibiting the denial of the Holocaust. For obvious reasons, such laws exist in Germany, Austria, and Israel, but it turns out that they exist in large numbers of other places without as much of a targeted history as Germany, Austria, and Israel. So Holocaust denial is, for example, unlawful in Canada, although it is not in the U.S., and countries vary with respect to whether they make this unlawful or not. Some countries, France, for example, are quite vigorous in enforcing their laws of this variety. France, it turns out, is also quite vigorous about enforcing their laws about racial vilification and incitement to racial hatred and so on. Once again, the arguments in favor of such laws are that it is just not true that when someone says something false and someone responds to it by saying that's not true, that the truth prevails over time. The argument the other way is that once again, this may be too dangerous in the hands of people who have different ideologies. There is a nice example of this that goes back 7 or 8 years in Turkey. It is illegal to say that there was an Armenian genocide. 10 years ago in Switzerland, someone was prosecuted for denying that there was an Armenian genocide in Switzerland, in Turkey. And the fact that that which is unlawful in Turkey is required in Switzerland, just to give one example, is at least an example, some would say, of the dangers of it all depends on who's making the determination. And in cases like this, maybe it turns out that the power of the Armenian community in Switzerland is stronger than the power of the Armenian community in Turkey, so that we have this odd contrast, and that's dangerous, and we ought not to have laws of this variety at all. That's the debate about this. And let me somewhat more briefly just mention the other 3 areas beyond hate speech in which we see some number of modern controversies. So one of them is the question about libel or slander or other forms of statements that are damaging to reputation. Once again, to repeat what I said a little bit yesterday, for those of you who were here, once again, the U.S. is an international outlier in ways that most people, including some Americans, think gives far too little protection to reputation. So the basic idea of libel is that if I say something about someone that damages their reputation, that is a form of harm, especially if what I say is factually false. That is a form of harm that cannot immediately be combated by others responding that it is, after all, false. So the U.S. as I said, is an outlier on this question. In 1964, the United States Supreme Court decided a case called New York Times versus Sullivan that people throughout the world know about, criticize, argue about, and so on, in which, at least in the context of the civil rights movement of the 1960s, the U.S. Supreme Court said that statements about public officials cannot be the basis for a libel action brought by the public official unless the public official can show that the statement was false and can show that the person who made the statement knew that it was false at the time that it was made, and show this by clear and convincing evidence. In other words, proving by clear and convincing evidence, a stronger burden of proof than mere preponderance of the evidence, show by clear and convincing evidence that the person said something false and knew it was false when they are saying it. That is almost impossible to prove. It's not so hard to prove falsity. It is very difficult to prove intentional falsity. So one consequence of this is that libel actions brought by public officials in the U.S. have pretty much disappeared. Throughout the world, journalists in particular have urged courts to follow the U.S. model. Every court that has been asked to do so has said no. The UK, in a case called Reynolds, said, no, that goes too far. Maybe journalists and maybe newspapers should be held liable if they are negligent, not just intentionally false. So too in Canada, so too in a large number of other common law and non-common law countries that have said the balance between reputation and freedom of speech is a difficult one. The U.S. doesn't understand the arguments in the other direction. And in most countries, even countries that recognize freedom of speech as important, libel remains real. It remains a genuine cause of action, even if more recently it is somewhat, the burdens on someone trying to prove it might be greater than they have been in the past. Indeed, one of the things that makes the U.S. even more extreme here is that a few years after New York Times versus Sullivan, the U.S. Supreme Court said this is not just about presidents and senators and members of Congress and governors and mayors and other public officials. It's also about public figures. So therefore, it also extends to television chefs, football players, and all other public figures that if something false is said about them, for all practical purposes, they do not have any redress. They do not have any cause of action. Here again, much of the rest of the world says this goes too far. Third category is invasion of privacy. That is the fundamental idea of libel comes out of saying things that are false. But it also turns out that for most of us, there are lots of things about us that would embarrass us, even though they are true. So I don't want to get into too much detail here. Maybe I don't want to get into any detail here. But all of us do things that the publicity about these things would be embarrassing, even if they were true, even if they were accurate. So I will give a somewhat mild example. Suppose someone follows you into the bathroom with a cell phone camera. You are doing something in the bathroom that you do however many times a day, and every other member of the human race does a few times a day, and someone takes a picture of you doing it and puts it on the front page of the newspaper. There is no falsity involved at all. Nothing has been done except speech in the larger sense, communication. But I think for many of us, we would consider this an invasion of privacy. Invasion of privacy is therefore about truth. And the question is, are there true statements, embarrassing facts about your past, embarrassing things that you do right now, that when publicized will hurt you, and you should have some form of legal redress. Final category that I will mention, and then we can talk about all of these, an area that's increasingly talked about in Western Europe, maybe here as well. Should free speech, should the idea of free speech, should the idea of freedom of expression extend to commercial speech, commercial advertising? It turns out that there are lots of forms of commercial advertising, advertising of products, that some think is dangerous. Advertising cigarettes, advertising alcohol, advertising various other things, sometimes accurately, sometimes not accurately. In most places, not in the US, in most places, the general view is that commercial advertising, trying to sell a product, trying to sell cigarettes or beer or wine or hard liquor or automobiles or anything else, just has nothing whatsoever to do with the idea of free speech. And if government wants to restrict cigarette advertising or alcohol advertising or the advertising of stocks and bonds, free speech is totally irrelevant to this topic. Once again, led largely by ideological libertarians or political libertarians. In the US, people who object to government regulation in general have persuaded the US Supreme Court that there are free speech dimensions of even commercial advertising, even trying to get you to buy a product solely for the purpose of profit making by the manufacturer of the product. And once again, the US is somewhat of an international outlier about all of this, but it's being debated in a large number of other places. Okay, I could mention a whole bunch of others, but as I promised at the beginning, I'm not going to. So I will stop at this just with libel, hate speech, privacy, and commercial advertising as examples of a large number of the kinds of contemporary controversies that we see about freedom of speech, even in open liberal democracies. Again, as I said yesterday, there is a range of views. The US is at one extreme. Most other countries are somewhere else. I'm not talking, when I say somewhere else, I'm not talking about North Korea or Saudi Arabia or Zimbabwe or some number of other countries that we might not think of as liberal democracies. Rather, there is a range of views within liberal industrialized democracy about all of the topics that I've mentioned. And with that, I will stop.
Okay. All right. Antes de passar a palavra para o professor Ronaldo Porto Macedo, da Universidade de São Paulo, Eu queria agradecer a presença de todas e todos, especialmente dos nossos professores aqui, a professora Kátia Kozik, a professora Ângela Fonseca, o professor César Serdena, que organiza junto esse evento, o professor Rodrigo Kanayama, o professor Sérgio Alenhart, que está aqui também, que é um entusiasta também da vinda do professor Schauer, professores parceiros de outras instituições, o professor Ricardo Calderon aqui, o professor Renê também, e tantos outros. Me perdoem, aqui o professor Andreoni, né? Fernando Andreoni, e o professor Márcio Berclas, que eu estou vendo aqui também. So many colleagues that came to listen to you and to Ronaldo. Então, agradecer a presença dos colegas, agradecer a presença desse público absolutamente interessado, seleto aqui da nossa faculdade, de instituições parceiras, e de imediato agradecer também a vinda do professor Ronaldo Porto Macedo para fazer esse debate, essa interlocução, ele que é também um especialista em liberdade de expressão e em teoria do direito, e que conhece muito bem o trabalho do professor Schauer. Então, imediatamente eu passo a palavra ao professor Ronaldo Porto Macedo. Sorry for speaking in Portuguese.
I'm sorry, I don't understand
from
it.
From now on, we get back to the
That's
English.
okay.
All right.
Okay. Okay. Is it okay? No. Maybe.
Okay. Alô?
Okay. First of all, I'd like to thank you very much for the invitation. It's a renewed pleasure to have the opportunity to not really to debate, but to learn more with Professor Schauer. We had already had a similar opportunity other times. It has been wonderful for me to know more about freedom of speech and Fred Schauer's ideas. Well, Professor Schauer really tried to map some of the most interesting challenges and debates in freedom of speech, and listening to him, I was really very curious and pressed towards asking him more about what was not said in his speech. So this is something that I'd like to do, and the other thing I'd like to do is to maybe press him a little bit more to be more, let's say, normative, to express his own ideas on some of these issues. So, but before that, I think that is extremely important. This is my view, and I have been advocating for this, to update somehow the Brazilian debate on freedom of speech, update it to what is being discussed abroad. And I think that United States, and I believe that Professor Schauer would agree, at least with this, with me, it's an incredible laboratory for understanding, for the developing of both the theory and also the practice of freedom of speech. No other country in the world has such a long, non-interrupted history of discussing and, in a way, I wouldn't say really always perfectioning, but many of the issues that it has been tackled by the U.S. jurisprudence has been the effort of many decades, of many accumulated efforts of many scholars and judges, etc. And it's hard to find in any other jurisdiction such a rich debate that you can find in the United States. So I think it's something absolutely necessary and very welcome to update our debate to what is being done elsewhere. And Brazilian debate tends to be very confusing, very puzzling, very erratic in many ways. So this is another additional reason why we should really celebrate talks and speech such as this, and also the effort to understand the American jurisdiction. So let me go more directly to some issues that concern me, and I think that Professor Schauer has a lot to talk about this. One of them, I think it's connected with the methodology of freedom of speech, how to deal with freedom of speech cases. We have here in Brazil a very huge trend towards applying the balancing method of legal interpretation according to some kind of vulgata, a simplified way of importing, especially Robert Alexis' ideas of the proportionality test. And this, let's say, reductio ad Alexis way of understanding the balancing process has a lot of side effects, I'd say, theoretical and practical side effects. First one is, according to Alexis, there's some kind of assimilation of two ideas that many other authors try to separate, which is the idea of interest or public interest or social interest and values, public values. So in a way, many authors, let me just quote one of them, like Ronald Dworkin, would repudiate, would refuse the idea that we can mingle, that we can merge the idea of interest together with the idea of values. And there is a method of balancing values, but we cannot simply assimilate them as if there was the same thing. But this is very current in Brazilian practice, and I think this is something that is, I would say, a flaw in Robert Alexis' own ideas. And besides that, even if we accept this idea, what is commonly made by Brazilian courts when they interpret freedom of expression cases is simply to adopt some kind of general weight of some values like dignity, human dignity, or health, or some other, and try to make some kind of ad hoc balancing test as if these values would be commensurable according to some kind of weight. So, and in my view, this has produced and is still producing a lot of erratic, irrational kind of legal decisions by the courts. But there is some kind of more refined way to understand the proportionality test, or to understand this kind of balancing applied, for example, to hate speech cases. Jeremy Waldron, for example, in a recent book about hate speech, contesting the American exceptionalism and challenging it. At the end of the day, he ends by adopting or accepting the idea of balancing as the true method for dealing with cases about hate speech. And there is, again, just to map some other debates, there is a very interesting debate about Jeremy Waldron himself and Ronald Dworkin about hate speech, in which this issue about how to analyze the application or the adequacy or using the proportionality test for dealing with hate speech is a valid one or not. So this is my first question. Connected to this issue about methodology of hate speech, I would add a second one, which is for many authors like Baker or Dworkin or Robert Post, just to quote some of the American scholars, they very deeply connect the key concepts connected to hate speech jurisprudence, but also to the analysis of concrete cases, to a very clear and political philosophical discussion. So the political philosophical discussion would be, we have to put our hands to go straight into a discussion about theory of justice or political philosophy in order to understand what is the correct meaning, or what is the correct conceptualization of the concept of autonomy or democracy or freedom, etc. In this way, whenever we appeal or claim to make a normative theory about freedom of speech, we somehow are necessarily involved in a political, philosophical, and, so to speak, normative debate about freedom of speech. Other authors, though, tend to accept a more, let's say, positivistic way of understanding freedom of speech, which I think is very common here in Brazil. What I call a positivistic way of understanding is simply understand the writing of the Constitution, what is there on the legislation, the criminal law or the civil law that is applied about compensation, etc., and simply understand this area of law as in the same way as we would understand other areas of law, like traffic law or like tax law. And this is something that is also challenged by this other view that sees a very deep connection between political philosophy and legal theory. So the point would be, what kind of legal theory is applied here, is required both at the jurisprudential dimension and also at the practical one. My third point is about some of the categories that are very well known and I think very well established in American jurisprudence on free speech, which unfortunately are not so well established in Brazilian law. And I'll cite some of them. The first one has already been mentioned by Professor Schauer, which is the concept of incitement and advocacy of ideas. Very commonly here in Brazil, we tend to understand incitement in a very broad understanding of the word, by which we can understand why I can incite ideas, I can incite someone to think about, like a poet can incite something. Anytime someone says something, he will be inciting some kind of emotion or ideas. However, according to American law, incitement has a much more clear and definite meaning. That means provoking something that can be immediately recognized as able to produce an effect, and not simply producing some kind of general effect. And that's the reason why this idea of advocacy of ideas is protected and incitement of a crime is not protected. So my question here is really, what do you think, Professor Schauer, about this distinction? Do you think it's really a well-established one, a departure point? And finally, not to take all the time, I would like to hear more about another very well-known kind of argument for supporting a very liberal freedom of speech approach, which is the risks of if we do not protect it strongly, this could produce a silencing effect into the audience. That means if we allow all the possible damaging discourses in society, if we could allow that everything can be brought to courts, and in a damaging, in a claim for damage could be accepted by court, this could produce a silencing effect. That means it just can create a very strong incentive for people not to express themselves. Of course, this is an empirical claim. However, United States is famous for producing a lot of empirical data, including about this issue, and this also brings together a very question that connects a theoretical point and an empirical one, which is, how should we measure these risks, the risks of silencing and the risks of producing or enforcing or reinforcing some kind of prejudice in society? How can we imagine? Should state and how should we understand something that many authors try to import, at least in Brazil, try to import into the decision making about freedom of expression, which is how should we import some kind of precaution principle inside freedom of speech case? That means, should we, whenever we have some doubts, whenever we have some possible negative side effect, what should we do? Should we forbid the speech, or should we go ahead, study more, and until there's no clear data showing that this is the bad effect, the principle, the standard view should be to allow freedom of speech broadly. So this, well, let me just add, if you have, but you don't have to talk about all the points, but I would like to know what's your opinion about the so claimed by some authors autonomy of religious speech in face of the general principle of freedom of speech. Because in many jurisdictions, like in Brazil, many authors think that there are two different, there's some kind of stronger protection of religious speech. So hate speech produced by a religious priest, for example, will be more strongly protected than the same speech that if it was made by a non-religious person. So many authors, and again, Dworkin is one of them, would deny that there is some kind of independent principle of religious freedom of speech. And again, I think this is also connected with a theoretical question, which is about the value pluralism, because one side effect of accepting legal pluralism and the incommensurability of many different values in society is to say that the only way to deal with them is to make some kind of balancing, because we will necessarily always sacrifice some principle or value whenever it clashes with another one. However, other perspectives try to, instead of merely accepting by principle, by definition, as a kind of automatic assumption, the incommensurability and the clash of principles, try to recommend or suggest that we should rather try to follow a methodology that will at least try to reconcile these clashing principles, instead of simply admitting that they are unavoidably clashing all the time.
Okay, so this is all interesting and important. I thank you. Let me say a little bit about each of the things that you've mentioned. I will start by saying you invite me to be more normative. I'm going to decline the invitation. I find that the older I get, the less interested I am in my own opinions. So I will leave the strongly normative claims to others. But a couple of observations. One, before we get to the more particular ones, you mentioned that the U.S. has you say the U.S. has a long history of dealing with all of this. I think at least some people in the UK in particular, or other common law countries, would say it's not just the US, we have a long history as well. That the typical British view would be, we have a long history, we don't have a single document written constitution, but we have hundreds and hundreds of years of common law adjudication, and in dealing with questions of incitement, libel, privacy, slander, and all of these other questions, common law judges have been dealing with this for hundreds of years. You may not like the answers they would say, or you may like the answers, but it's a mistake to think that we haven't been dealing with them. They would probably give libel as the best example. There are literally thousands of English reported cases on libel going back 300 years. They say, we've been dealing with this on a case-by-case basis. And then the question is, which I'm certainly not going to give an opinion about, is what are the virtues and vices of the common law compared to the civil law? The British would say, in a common law system, we work out principles in the context of real cases. Judges have been doing this for a long time, and it's a mistake to think that we haven't been dealing with these issues. Now, the English have a tendency to glorify the common law, believing that whatever 200 years of decisions by people with robes and wigs have come up with is good for that reason. But at least there are interesting questions here about how to work out the principles. And I think in some number of common law jurisdictions, they would say, we've been doing this too, even if we haven't come to the same results as the Americans. So that leads to the question of methodology. Alexei, the Canadians, the South Africans, the Germans, and some number of others glorify proportionality. It's the big word these days in comparative constitutional law. It opens a few questions. Question one about proportionality is who's doing it? That is, there is at least a view that proportionality adjudication, proportionality decision-making, as you say, is a form of balancing. And then the question is who's doing the balancing? And talking about it as proportionality, which is a bigger word, doesn't eliminate the question of balancing. It doesn't eliminate the question of weighing. And then the question is, who does the weighing? Moreover, there is also the question in proportionality adjudication of what weights do different values get? That is, will there be a thumb on the scales, as the metaphor would put it, for certain values? If so, for which ones? Just talking about proportionality doesn't answer the question. For example, so to take an example from the German Constitution, the German Basic Law. The German Basic Law, for philosophical and historical reasons, places great weight on human dignity. So then the question is, what is it to say that we will engage in proportionality analysis in deciding how much of a loss to human dignity is worth how much of a gain to freedom of expression? Yes, there has to be balancing, but merely saying that the restriction has to be proportionate to the importance of the interest on both sides may not get us any further than just saying there has to be some balancing, and proportionality without a prior determination of which interests are more important is pretty much no different from open-ended, non-constrained balancing. If you say to the Germans how much of a loss of human dignity is proportionate to how much of a loss of freedom of expression, the answer has to be that there must be a prior determination of which of those things is more important. And if we don't know which is more important, then it's hard to see that proportionality is a particularly constraining form of method. Now, We may not want a particularly constraining form of method, and then we have to decide how much we want to trust the judges. There's also a question, as you raise, about incommensurability, as it is put in the philosophical literature. That is, can you balance things that are very different? And of course, it's one thing to say, maybe it's hard to balance, well, let me put it differently. Sometimes the issue comes up in terms of freedom of speech as a value against mere interests or mere policies. But when, especially in things like hate speech or libel, when somebody says dignity is not a mere interest, it's a value. It's a value with as much philosophical and moral foundation as freedom of speech or autonomy. Reputation is a moral value. It is something that's morally important. It's not entirely clear that the typical argument for restricting freedom of expression is an argument from mere interests, even if we think that interests cannot be balanced against principles. Moreover, as some number of philosophers, Judith Thomson most prominently, have made clear, merely saying that something is a principle does not mean that it automatically prevails against all sorts of things that are interests. There may be particularly important interests, or lots of them, that can and must be balanced against principles. So this then leads to a question of how much philosophical and political philosophy should we be engaged in when we do this. So you mentioned that freedom of speech is different from traffic law. Maybe not. We think that traffic law is different because traffic law is put in terms of very clear, crisp rules. But traffic law doesn't have to be. Suppose that there were two provisions, and I say this with some trepidation when I say, suppose there was this provision in the Brazilian Constitution. In general, whenever I think, suppose there was this provision in the Constitution of Brazil, there really is. They're all there. But suppose there were a provision in the Brazilian Constitution that said that traffic laws should be made in order to maximize safety, in order to preserve the importance of human life, in order to preserve the importance of transportation, while at the same time recognizing the importance of human life. Lo and behold, all of a sudden, we would be engaged in a philosophical discussion about how much of a sacrifice to transportation efficiency is worth how much of a gain in protection of human life. Fewer people would die on the roads of Brazil if there were a national speed limit of 50 kilometers per hour everywhere. There isn't. I'm not sure there is a speed limit anywhere, but that's a different question, even when there are signs. But these are philosophical questions, no different from free speech questions. We think they are different only because freedom of speech or freedom of expression is typically couched in broad, general, vague terms, and traffic laws are typically more concrete, but they don't have to be. And even concrete traffic laws, speed limit 100 or speed limit 110 or whatever it is, reflect background principles. about the importance of safety and the importance of efficiency. And then the question, a very familiar one in legal interpretation, is should concrete laws be interpreted in light of their background purposes and background principles? We do that. We must do that with freedom of expression, but we do that with traffic laws. For those of you who I gather today started your study of jurisprudence, philosophy of law, at some point you will encounter, I hope, the debate between H.L.A. Hart and Lon Fuller about no vehicles in the park. One view, Hart's view, would say no vehicles in the park means no vehicles, and we can understand that based on the language. Another view, Fuller's, would say we cannot apply this law unless we understand its background goals, its background purposes, and so on. That may not be any different from freedom of expression. Two other brief things on incitement and advocacy. Yes, the U.S. interprets incitement very narrowly. Most other countries have a healthier understanding of this, but again, if you interpret the idea of incitement very narrowly, the consequence of that is that all sorts of advocacy that is going to have an effect, is in possibly a dangerous effect, will be out there. So the cigarette companies don't think that as soon as you see an ad for cigarettes, you are immediately, if you've never smoked before, going to take up smoking. They do think that if they advertise cigarettes as a way to a happy life, good sex, and all of the other things that the cigarette companies associate with smoking, that over time there will be more smoking. So too with the ads for beer, so too with the ads for lots of other things, so too with the ads for cars. So if you think that BMW if you agree that BMW understands that if it advocates buying BMWs because it will produce all sorts of good effects, then is there any difference between advocating the buying of BMWs and advocating hating people because of their race? If we want to say that advocating hating people because of their race ought to be protected because it's not incitement, we have to recognize that just like advertising BMWs or Marlboros or beer, it is still going to have an effect, and we can't avoid the question about balancing. Finally, a bit of something about silencing. There is an important strand of discussion about and around freedom of speech that started with the feminist theorist Catherine MacKinnon, that has now been made more concrete and more detailed by some number of other feminist philosophers, perhaps most prominently these days, Ray Langton from the University of Cambridge. What all of these people are arguing in the context of speech that urges or encourages or glorifies sexual violence or sexism is that the silencing goes the other way, or that the silencing goes both ways. That is, when somebody says, MacKinnon argues, when there is the message all around us that women are not worth listening to, when there is the message all around us that women should be thought of as just the objects of sex or sexual violence, what that does, says MacKinnon and Langton and others, it silences women's voices. Women are no longer taken seriously. They are silenced by virtue of all of the speech that takes place around them. And that is a mistake to think that laws protecting free speech are the only forms of silencing out there. Speech can silence as well as restrictions on speech. I'm going to stop with that and let others talk, discuss, argue, ask, whatever, but I will leave it. I will silence myself for a minute. Yeah.
At least you made some normative points.
Sort of.
Vamos tomar mais algumas questões, né? Quem quiser fazê-las. Professora,
was very nice to hear you.
Is that microphone?
Something fantastic. As you finished talking about the feminist theories, I remember when you talked about, when I was just arrived here, about the difference between speech and communication.
Yeah.
So I remember that Butler, when she assumed the Adorno's Prize at philosophy, she said that we must now understand that if we have a long and very strong tradition in political vision, that rational speech was the category that begins to make us lead to the political action, the political area, we must understand that what's behind this is that precarity is not political. We are just in politics when we speak rationally. And then she says, well, it is like that. We does not see like a lot of communications that's not rational speech communication are political, and like precarity is a form of politics. And this must make us see how our world of rational speeches are always tensioned about this political communication.
Right.
This is one thing. And I think this is very important today because we're speaking about political performativity.
Yeah, I mean, good.
In Brazil, this is very, very strong right now. And another thing I want to ask you is, just because in Brazil we see like right now this balance very strange over regulation and liberty. This is very difficult in our field, but we see that there is some of very liberal persons that always seems to claim that there's some danger and some crisis over personal moral actions, and with these dangers and crises, they seem to lead us to a necessary regulation over this that would be a liberty. How do we balance this? How do we take this? Is a strategy.
Yeah, so I'm not going to answer the last question, but a few observations about it's all political and the rational, irrational, or rational political distinction. This, again, is an area in which at least my country, the U.S., has been wrestling with for some time. Perhaps the leading Supreme Court decision goes back exactly 50 years. 50 years was pretty much at the peak of objections, political objections to the war in Vietnam. And one reason for the American somewhat extreme approach to freedom of expression is the, at the time, a desire of the Supreme Court to protect those who were protesting against American involvement in Vietnam. A young man named Paul Cohen objected both to the war in Vietnam and objected to the fact that there was, because of the war in Vietnam, military conscription. So his political rational message was, I object to the war in Vietnam. It is not in the United States' interest. It is an immoral war. And I also object to conscription of unwilling young people, young men, to fight in this immoral war. And this system that has created conscription. You can't put all of what I have just said on the back of a jacket. So Paul Cohen walked around with a jacket that said, "Fuck the draft." And the response of the officials to his jacket that said, "Fuck the draft," was to prosecute him for creating a disturbance or disturbing the peace. Case gets to the Supreme Court. One argument by some of the justices was, this is not rational speech. This is just inflammatory. The same thing could have been said in a less inflammatory, less offensive, more rational way. A majority of the Supreme Court said, once we are in the realm of politics, we can't distinguish the rational from the irrational. It's all politics. And that the realm of political speech cannot be limited to those who would express their political views rationally. That's been, for better or for worse, American law for 50 years. There's a lot of irrational political speech out there, and to some extent it started with this. You also mentioned, the other thing you talked about was the risks of overregulation. Let me come back to the precautionary principle. Suppose we were not talking about freedom of expression, but we were talking about environmental law. Environmental law operates in a world of uncertainty. We don't really know what the effects of climate change will be in 50 years. We don't really know what the effects of fracking as a way of oil discovery will be in 50 years. And many environmentalists say, under circumstances of uncertainty, the precautionary principle says we should regulate because we don't want to run the risk of under-regulation. There is an interesting contrast between freedom of expression discourse that always worries about the dangers of overregulation and environmental discourse that always worries about the danger of underregulation. But one of the things that McKinnon and Langton and the Advocate and Waldron and others say is, once we recognize that speech has consequences, there are dangers to underregulation as well as dangers to overregulation, and maybe we should think about the precautionary principle with respect to speech as well as thinking about it with respect to climate change and fracking.
Ok. Luiz Krasuski.
Yep.
Pode se levantar, Luiz? Fica melhor.
Again, yesterday, there discussing themes in a more philosophical approach. One of the questions that was raised is based on the idea that it's important to see where to draw the line regarding regulation of speech, etc. I want to ask you, in this Professor Cedro's lecture as well, here in Brazil, courts are called upon to decide cases, and at least the lower courts cannot decide to not decide those cases.
Yep.
So they are, in a way, constrained to present a solution, even though it's not the greatest one, considering a systematic approach to freedom of speech or how this particular decision can impact freedom of speech in general in a country. Is there a better methodological approach to building precedents regarding such themes, but it's a better approach to deal with it in a case-by-case basis? Like, in a way, the Supreme Court of the United States have been doing for the last at least 20 years or 30 years, in which the swing vote in the court gets a lot of power because every case must be heard. Because in one case we are deciding if compelled speech is right or wrong. In another case we are deciding if this religious relativism is protected by freedom of speech clause as well. Which way, Professor Schauer, believe that is best for dealing with this? With this reality, we have to decide cases, and those cases will, in a way, get to our Supreme Court.
So, yeah. So, at least traditionally, as I mentioned briefly yesterday, one of the arguments for developing principles in this area and not deciding too much case by case is that, like most of the people that raise claims about unfair procedures in criminal law, most of the people who raise free speech claims are miserable people saying bad things. And if at least part of the idea is that there has to be some degree of protection of even miserable people saying bad things, however much we can argue about, it may be that systematically, like with criminal procedure, free speech claims are going to be made by unpopular people. And if systematically they are being made by unpopular people, there are risks of case-by-case decision-making, because every claimant of a free speech principle or a claimant of a free speech right will look like a bad person and will come with a burden of proof or burden against them just because of who they are. If we think, open question, if we think that freedom of expression is really important, it may be important to protect that by resisting too much case-by-case decision-making, because too much case-by-case decision-making will incline against protection because of the character of the people that are claiming the right.
Silvana.
Sure. I was thinking about the comments of Professor Ronaldo, and I would add what's your opinion about this technological interchange of information? We have the free of communication and expression through our smartphones. And for example, the WhatsApp company encrypt our messages. And you have to balance between some prosecution of crimes that are made by smartphones. This kind of conflict is actual. How to think we need a new theory to deal with this technological and the internet environment of free speech.
So let me make a totally non-controversial factual statement. John Milton, John Stuart Mill, and Oliver Wendell Holmes did not have smartphones. So it turns out, so the question then is, now that communication is so much easier and so much faster, what does that say about free speech principles? But at least one way of thinking about this is everything that we say when we talk about freedom of expression is emphasized or exaggerated or in the era of smartphones and electronic communications, but it's exaggerated on both sides. That is, all of the harms are greater, but all of the benefits are greater. And I'm not sure there is any systematic way of saying that smartphones increase the harms of speech but don't increase the benefits, or vice versa. So it might be that although it is fashionable to say that all of the traditional arguments are irrelevant in the era of modern technology and modern electronic communications, it's not clear that this modern stuff has more of an effect on one side of the balance than on the other. Now, maybe this is just the self-protective observation of someone who's been thinking about these things for a long time, and like most people of my age, I am technologically inept compared to most of you. So it's obviously in my interest to say not very much has changed. But I do think when we think about the changes, and when we think about the fact that smartphones and the internet and everything else have increased the harms, which they have, maybe they have increased the benefits as well.
Mas, além de você, mais alguém que daí a gente pode colher, e daí, então a gente tem 2, 3. Então, e daí we have 3 more, and we
Okay.
and then
I answer, and then we
yeah. Okay.
Yeah.
All right.
Free of speech.
Yeah. Então aqui, ali e ali. Podia falar o nome, que daí a gente apresentar, né?
I'm student here. My name is Pedro. My question for the professor is intellectual property being debated in the freedom of speech discussion? In a way, I can't sing a song that was wrote by another person without paying the royalties.
Yeah.
Okay.
Good.
Hi, Professor. I'm Marcelo Vivian. Thank you for speaking.
Marcelo.
You mentioned 12 controversies about the freedom of speech. Maybe this one is one of them. But can you talk a little bit about the right to be forgotten, like labor case, but specifically in the United States, please?
Marcelo.
Hi, Professor. My question is about free speech inside public. And I know the United States, recently in the last year, they had problems with speakers like Benjamin Beadle or Charles Murray. They are being banned, or they made a lot of demonstrations against speech. However, even among top schools, teachers that study freedom of speech, like Robert Holmes, and they disagree about it. Some of them say that universities is a place for a student to learn, so they can ban using controversies. Others say that they cannot do that. So, and I think just a matter of time before that started to happen in Brazil, that members of the so-called outright come try to speak. Do you believe that the university or college, they have the autonomy to actually ban the speaker based on their point of view?
Good. Okay. 3 important but brief questions. I'll respond a little bit to all of them. So there is just beginning in a number of places debates about intellectual property and freedom of expression. Those debates traditionally did not take place in the US because of a peculiarity of our Constitution. That is, Congress in the original Constitution, 1787, is granted the power to grant copyrights and other protections of intellectual property. The protection of freedom of speech in the First Amendment did not come until 4 years later. So as a matter of technical constitutional interpretation, the traditional view was that copyright precedes freedom of speech as a matter of technical interpretation, and therefore the realm of copyright, the realm of intellectual property, doesn't touch on free speech. Only over the last 10 or 15 years have these debates started to take on a free speech cast. The argument on one side is when I copy something, I'm engaged in free speech. And the argument that is also that we all copy. None of us is truly original, and we are all copying. We are all stealing from everyone else, and that's the way the world gets better. And the argument the other way is people are not going to produce things unless they are protected in doing so. Only in recent times has this been debated in free speech terms in the US and elsewhere. I think it's right that it's be debated in free speech terms. I'm not sure what the answer is, but at least the historical peculiarity of copyright having been around longer has stifled some of the debate until recently. So the right to be forgotten, a bigger issue in Western Europe than elsewhere, really relates to the question of privacy. Do I have a right to be forgotten? Do I have a right to be ignored? Do I have a right that people not talk about me? It's in the same category as privacy. That is, when something is said about me, even if what I originally did or said was public, do I have a right that it be ignored? There are in the US and elsewhere privacy cases that deal with this. Some of the more important US cases, not from the Supreme Court, deal with people who were famous in their childhood, famous or infamous in their childhood, but want to put that behind them. Do they have the right to put it behind them when others say, you were public once, you are public forever? That's, again, a real debate. It's about privacy. It's not about truth. And at least the American view, which may go too far in one direction, is if it's true, you can say it. And that may go too far in under recognizing the importance of privacy or forgottenness kinds of interests. Finally, there is, when we think about the kind of people you were talking about that have created some of the controversies on American campuses, there is an interesting question. When a university invites someone to speak, is the university endorsing them? And at least many of the arguments on behalf of those who protest, demonstrate, and so on say, if Ben Shapiro or Ann Coulter or any of these people want to speak out there in public on their own property or in a public park, that's fine. Once they get invited to a university, the university is endorsing them. And what we are protesting, they say, is not them, but the university's endorsement. The response to that is, no, when we invite someone, we are not endorsing them. They are data. We are inviting Ben Shapiro and Charles Murray and Ann Coulter to campus so that people can be exposed to their views, so that people can see them the same way that we invite, in a figurative sense, in the same way that we invite dead animals to our laboratories so that people can inspect them and study them. These people are being invited so that we can study them. Now, it is at that point that some people, and this goes back a little bit to the question earlier about rational speech, there are people who say there is a distinction between what a university should do about people who argue rationally and seemingly scientifically, like Charles Murray, and those who just make inflammatory speeches. There ought to be a difference, so the argument goes between those who make arguments, even if the conclusions of those arguments are wrong, and even if the conclusions of those arguments are dangerous, there is a difference between those who make arguments with arguments and data and those who would just be inflammatory with no arguments, no data, and so on. I think there is something to be said for that. Here, it turns out that the U.S., unlike much of the rest of the world, is not an outlier. That is, universities as centers for fervent, enthusiastic, and sometimes violent political debate did not start in the U.S. There was more of this in France in the 1960s than there was in the U.S. And in some important ways, universities as inherently and necessarily political, and universities as sites for political argument is not so much an American phenomenon. So I have some sympathy with the distinction between what kind of view and what kind of argument. As an academic, I think I am uncomfortable with the notion that people should be not invited just because of the consequences or of their views. It may be that universities are just different than other places. And with that, I will stop.
Okay. Well, I'll exercise my freedom of expression right now. And on behalf of the law school, I'd like to thank you very much for your seminars and your lecture yesterday. Was really a pleasure to have you here. Yesterday, I told you that I read that Justice Thomas recently said that New York Times versus Sullivan was a mistake, and I'm a little bit afraid of his statement. And today you said that it went too far. Hopefully, what it's maybe if the Supreme Court comes to a new decision, it's going to be something in favor of freedom of speech and not against it.
We will see.
Oh, well, let's see. Anyway, thank you very, very much for coming. Professor Schauer arrived on Sunday and is leaving today. So it was a tough agenda. He has a tough agenda. We hope we will have you sometime, maybe next year here. So thank you very much.
Thank you.
Thank you, Ronaldo, for coming also and join us in this seminar. You are always very welcome here, and it's also a pleasure to have you here. Thank you all. Thank you.
Professor, I'd like to thank you.
Thank you.
Congratulations for your speech. I was last week. I was at Harvard for a speech about social networks and freedom of speech. I was about the problem of the companies and the freedom of speech. When the companies guarantee or not the freedom of speech of the users.
Yeah.
And what the limits are.
That's an important. It's an important theoretical, philosophical issue. It turns out that because in the U.S. the Constitution only applies to government, it's not a constitutional issue in the U.S., but it might be in other places. Good.
Thank you, Professor. Thank you.
So, Shower, what do you think? I have your phones.
Yeah,
I wanted to.
that doesn't work.
Yeah, doesn't work.
Doesn't work.
We need the number of your passport. Do you want to try again? Here? Or do you prefer?
Passport. I tried that number. I tried the goal code, which is different from that. That doesn't work. I would be happy if someone wants to just call and ask to confirm if this is to confirm that I have a seat on the 6:55 flight.
Yeah. But have you chosen?
Vai que ele é meio.
But I think that was I chose 140. So I still do not have a confirmation from home that I am actually on this plane. That's what I need.
Yeah. But I think it's not a problem. It's coming to.
I will be happier.
Okay. I will try to do it.
So, you have the ticket number.
Yeah.
Okay.
This is another one.
This is the most recent. Yeah, 244.
244.
242.
It's different from mine.
Oh, okay.
I haven't tried.
Oh, maybe I mixed up the two. That's possible. Try that.
Okay.
But or try my name, or try something. But I would be happy to have a confirmation that I'm on this flight. That's all I need.
Yeah.
I don't care about the seat.
But they will fly with you to São Paulo, no problem. This is.
Qual que é a coisa?
É a Mari? Mari que é azul, né?
Várias tem.
Não, mas no ticket aparece Mari.
Não, dá pra ver aqui. O programinha da Azul, se você quiser ver.
So my
Perhaps I think that it's Go.
Yeah.
Go.
So my concern is not, I know they'll fly me, and I just want to make sure that if it's on a different reservation, I don't want to cancel from all of the others.
No, they will not cancel.
Você quer ver aqui? Professor, could you sign up for me?
Sure.
O que as companhias fazem agora? Já ouviu falar de Shadow Ban? Thank you very much. Qual que é a Facebook?
Vou tentar escrever
Simplesmente eles deixam escondida a fala. Então a pessoa continua falando, mas ninguém vai ver.
É um aplicativo que já tem.
Thank you very much.
Thank you.
As pessoas não veem mais aquilo.
Mas é uma forma de pagamento, né?
Exatamente.
É uma forma.
Só que a pessoa não acredita. Só que hoje em dia você pode ligar também para outra. Se a pessoa continua falando, escuta.
Was a dispute was attacking on civil procedure, constitutional law.
Actually, in Brazil, the theory of precedence is mostly dealt by procedural law students and professors. It's crazy.
Outra que só tirar do bolso.
So
Calma que vai.
have like I
Não, ele
tried
tá devagar.
I called Go yesterday.
Vai fazer um check-in.
Eu tenho que fazer na Gol, tá? E as outras eu não entendi se ele fez. Só quer confirmar.
No. So I think lunch is great, but I think if we can't talk to them, I think I'll go to the
Faça
airport.
tudo junto.
Quer tentar escolher?
Esse aqui é o aluno
Esse
da
é o
passagem.
e-ticket.
Só faz pelo...
0161.
Aqui só faz pelo... Ah, não dá para fazer aqui. Sim.
But before I forget, thank you. This is
É meu. Eu sou localizador.
Não, é porque não é daqui. Ele vai viajar depois.
Depois ele vai para não sei, acho que é Delta.
Delta?
Shower, which is your company after São Paulo? United.
But United, if I try on United, they say I have to check in with you.
Because you have to do it here.
Yeah, exactly.
Parabéns,
Perigo, né?
Eu acho que vai aparecer aqui. Porque na Gol não aparece, porque só vai ter o Gol Nacional.
É.
Depende da integração, né, da companhia. Esse da... Aí? Vamos lá. PS7. Será que é esquerda? D61. Eu queria falar, o first flight in order is operated by Varig, que é voo. Please check in with Varig. Pagou. Yeah. Do site da Gol?
No site.
We are trying to do here.
And United says
Yeah.
that this is the code, this is the goal code.
Ah, you have another code. Okay.
Yes.
Mhm.
MCUFI5. But goal claims that that doesn't exist either. Even though I have a piece of paper saying I'm on this flight. Yeah.
MCU. Aqui é, né?
Acho que é assim.
Não.
Sim.
Mas aqui, será?
That's all. MCUFI5.
Right. Three.
That's what they told me on the phone yesterday. 0162 44 288
Yeah, esse é do e-mail. That's right. Esse é o primeiro e-mail que eu pedi. 062. 27. 062 4224 27 280.
No, it comes from Europe.
Calma, então.
Mas deram esse número para ele.
Oh,
E não entrou também.
chauffeur one. I don't remember the name of it. It's not a single Genius, child genius.
Quando eu achei que era português, né? Às vezes eles não estão permitindo.
Provavelmente pode ser isso. Se eu não consigo fazer, porque vai ter que ser do cheque internacional. Você não faz.
I don't think so.
Tem que chegar lá. Tem que fazer a
E aqui pra gente sempre, às vezes é, né? Pode ser, daí não vai direto.
Okay.
Brazilian bureaucracy.
I think they want that you must go to the check-in professional.
Wow, that works.
Some restrict security, sometimes. So I expect that you have a time here.
Great. Yes.
Thank you. Thank you very much. I respect
Miguel, tem democracia e representação. Esse capítulo ele praticamente sobre democratização.
Se bem que para ele, o animal hoje é uma pessoa, né? Ele
é professor de ciência política.
Muito bem, é isso. Tá bom, obrigado aí pela ajuda aí. Tá bom, obrigado.
Thank you very much. Bye.
Boa sorte.
Obrigado. Sabe?
Tudo bom?
É, como é que você pode fazer com um projeto? Eu posso enviar para o e-mail, porque eu não está concluído ainda.
Você é Paulo de Tarso, né?
Isso, Fortaleza.
Eu achei que eu conheci um outro Paulo, mas ele também é de Fortaleza. Eu achei que era você.
Não. Ontem que eu falei com...
Mas eu conheci ele por e-mail e uma vez pessoalmente.
Ah, certo.
E ele estudava lá em Fortaleza. Você já me mandou e-mail? Tá, então eu já sei quem você é.
A professora velha indicada, a professora velha...
Você conhece a Melanie ou não?
Melanie, sim.
Você fez um contato com ela?
Eu fiz contato com ela. Ela que me ajudou a entrar em contato com você.
Ah, então eu sei.
Aí,
eu não terei retorno do projeto.
Não, eu disse que na verdade você pediu para que a professora estava aberta, eu não sei o projeto aqui também. E para analisar também o processo de seleção mesmo.
E você não passou na prova?
Não, e eu consegui muito sim fazer aqui na UFPR.
Ah, você não fez?
Aí eu
veio fazer?
eu fiz.
Ah, que pena.
Tá. Eu quero ver se eu...
Não, então manda de novo o projeto para mim. Aí eu comento com ele. Tá?
Tem interesse em saber tudo que é possível agora?
Sim, pode ser.
Eu queria fazer uma crítica aqui.
Por exemplo, da linha de pesquisa, eu posso dizer. Se está mais ou menos na linha de pesquisa.
Eu queria fazer uma eu ia do direito da Comissão Nacional do Mercado.
A partir da onde?
Pois é.
Por exemplo, o João tem uma crítica, um artigo que escreve uma crítica agora. Então tem várias críticas.
Exato.
Qual seria?
Na verdade, o problema que eu vejo...
Thank you.
Processo democrático. Então, eu queria debater nessa interseção entre superação do positivismo e democracia. O paradigma da democracia usaria sempre a democracia radical. E a superação do positivismo. Algumas ideias dele, mas
Tem que trabalhar bem o referencial teórico. Neurociência, neuroética, neurolinguística, eu creio, né? Mas uma área nova daí.